Welcome everyone to this Global Sanctions webinar on a recent judgment of great interest to the world of sanctions and constitutional law. I wanted to start by introducing globalsanctions.com as a bit of a plug for those of you who are not familiar with it. It's an online resource providing, I hope, fairly comprehensive news and legal information about sanctions regimes around the world. So please do have a look at it. We offer free trials and demos and free alerts for those who don't want a full subscription with all the benefits that brings. This webinar is about a very recent Supreme Court judgment of the UK Supreme Court handed down on Tuesday of this week in a case called Shvidler and the Secretary of State for the Foreign, Commonwealth and Development Office. It has been explicitly regarded by the Supreme Court and others as being a test case for the approach of the United Kingdom's courts to challenges which have become known as delisting cases, cases brought by individuals or companies seeking to challenge their inclusion in targeted sanctions regimes. And as you will hear, it does raise a host of really fascinating constitutional issues as well as issues of sanctions law. You may and are encouraged, please, to ask questions of my interlocutor, Lord Sumption. Welcome, Lord Sumption. We are completely delighted to have you with us. I'm told that audience members can ask questions by typing them into the question box. There should be a Q&A function, and we will do our best to have those answered. Lord Sumption doesn't need much introduction. I know him best as my former colleague and head of chambers, as well as being an incredibly distinguished barrister. He is, of course, also historian, author, and importantly for present purposes, a former justice of our Supreme Court. He is also now serves an extremely useful function, if I may say so, of being a commentator on legal issues of the day in a very welcome manner. I'm also going to plug his books as well as plugging my own website. He's written two books, well, lots of books on subjects such as the 100 Years' War and other wonderful history books, but a brilliant book called Law in a Time of Crisis, and another more recent one on the challenges of democracy, both written in a brilliantly informative and engaging style, and also on topics very relevant to today's discussion. What I propose to do is very briefly summarize what this case is about for those of you who have not had a chance to read it in detail. And also just to say that I am a barrister practicing in public and sanctions law, among other things. I have the privilege, as a number of public law barristers do, of acting both for and against the government, including in these sorts of delisting cases. I have no involvement in the Shvidler case, and so I'm in the happy position of being an interested bystander, sort of floating above and raising interesting issues about it. So by way of brief introduction, as a result of Brexit, the UK now has its own sanctions regimes under a statutory framework known as SAMLA, the Sanctions and Anti-Money Laundering Act. As part of those regimes, the United Kingdom's government draws up lists of people and companies who are subject to various restrictions, including those known as asset freezing restrictions, but also others. When it comes to the UK's Russia sanctions list, that list of individuals and companies is a very long list of several thousands of people. In order for the government to designate someone or list them, add them to these list-based sanctions, it's for the government, and in particular the Foreign, Commonwealth and Development Office, the FCDO, to decide if somebody is an involved person. That is the relevant statutory language in the regulations, and it involves ticking certain boxes to decide whether somebody comes within the very, very broad listing criteria. If they do, then there is a question about whether a measure is a disproportionate impact on any rights protected by the European Convention on Human Rights. So the issue of proportionality, which was very important in the case we're here to discuss. Eugene Shvidler, the applicant in the case, was added to the Russia sanctions list in the United Kingdom in 2022 for two reasons. One, his association with Roman Abramovich, his long-standing business partner, and secondly, because he was now formally the non-executive director, so no longer of Evraz, a UK company involved in the extractive sector. He challenged his designation under the challenge regime laid out in SAMLA, which consists first of a ministerial review, in other words, a review by the government of its own decision to designate him. That was rejected. And then in a court review, which is his entitlement under this Sanctions Act, he lost in the High Court and the Court of Appeal. And what we're here to discuss is what happened when his case reached the Supreme Court. Now, it's the first case of its kind to reach our Supreme Court, and for that reason alone, it's of great interest. Now, he didn't challenge the fact that he came within these criteria of being an involved person because, he was involved in the extractive sectors, and so he couldn't really bring a challenge based on that. And so the case revolved entirely on the important principle of proportionality. Was this a disproportionate interference in his property rights? And this was a particularly characterized case because as a British and American citizen, but importantly a British citizen, sanctions followed him around the world. In other words, under the Sanctions Act scheme, for somebody who is not a British citizen, sanctions apply and the asset freezing and other measures apply within the territory of the United Kingdom and to UK persons, but to UK persons wherever they are in the world. And so, of course, if you're a UK national like Eugene Shvidler, then the measures have effectively worldwide application, and that was an important part of this case. So he said this was a disproportionate restriction on my fundamental rights, the right to property and the right to private and family life. And a majority of the court, that's 4 out of 5 judges, rejected his case and said they thought that this was a proportionate measure. The judgment was written by Lord Sales and Lady Rose. Lord Reid and Lord Richards agreed. Lord Leggett dissented in strong terms, and we will come on to discuss both the majority judgment and Lord Leggett's dissent. But just to complete the introduction, and everyone agreed that the proportionality test was that came most significantly from Lord Sumption's judgment in the Bank Mellat case. For those who are not familiar with that, basically the proportionality test in this context asks 4 questions. First of all, whether the aim of a measure is sufficiently important to justify limiting a fundamental right. That was not at issue in this case because everyone agreed that the aim of trying to roll back Russia's war in Ukraine was certainly a legitimate and important aim. But secondly, what was very much an issue is the second part of the test, whether the measure is rationally connected to the objective. So here we have another Lord Sumption test that in Lord Carlisle's case, where Lord Sumption said, and I will hand over to him in a second, that the court must review the rationality of the supposed connection between the objective and the means employed. Is it capable of contributing systematically to the desired objective, or is its impact on the objective arbitrary? So that's stage 2 of the test, which was very much an issue. Stage 3, which was not, whether there was a less restrictive alternative measure that could have been used. And stage 4, whether a fair balance was struck between the rights of the individual and the interests of the community. And it's really stages 2 and 4 that this case is about. Everyone also agreed in the judgments that it is for the court rather than the government at this stage to decide on the question of proportionality for itself, and after much debate and discussion, that in a case of this significance, that it is for the appellate court, in this case the Supreme Court, to do that proportionality analysis for itself. So to complete the summary, what was the difference between the majority judgment and Lord Legate's dissent? Well, the majority judgment, in very brief terms, said that it was very important to give significant weight to the FCDO's institutional competence because this was the area of sanctions, which involves national security, international relations, foreign policy, and so on. The majority accepted the government's view set out in witness evidence that the measures were rationally connected with the objective, and that included its view that the effectiveness of sanctions depends on their cumulative effect as well as the impact on the individual. And on fair balance, they said that yes, there was a drastic impact on Eugene Shvidler and his family, but that it was outweighed by the importance of the objective. And Lord Legate, in his strong dissent, disagreed. He said that there was no rational connection and that a fair balance had not been struck. And that's essentially because, first of all, the very severe impact that the measures have in view of the fact that Eugene Shvidler is a British citizen, and these measures, as I've said, are a very serious intrusion because of their worldwide impact. He said that they strike at the heart of his right to live his life as he chooses. And therefore, such a serious intrusion, he said, requires very cogent reasons to believe that requiring someone to pay a serious price of this kind is actually likely to make a real contribution to the objective of bringing the war to an end. And he described their reasons in pretty strong terms, as being flimsy, as being armchair theories, mutually inconsistent, incoherent, inadequate, lacking in credibility, and in his view, not coming close to justifying such a drastic curtailment of liberty. He also described them as being Orwellian because they were penalizing an innocent person in order to try to incentivize others and in order to try to encourage someone to speak out in favor of government policy. Importantly, also, he said his disagreement with the majority judgment was about the separation of powers, that he thought that courts should play a greater role in considering an interference with fundamental rights of this kind, because otherwise judicial review in this context is of little worth. And he said, although the majority was right to recognize the importance of the constitutional responsibility and institutional competence of the executive on foreign policy issues, he thought they had given inadequate recognition of the role which in our constitution the courts are called on to play in protecting individual liberties. And he finished by saying that the courts are failing in their duty if they simply rubber stamp assertions made by the executive to justify invading civil liberties without subjecting those to critical scrutiny. So with that summary, over to Lord Sumption. Lord Sumption, can I ask you first, just in very general terms, what you think of the case, both the majority judgment and the dissent?
I think that you've got to distinguish between those aspects of the case which are of general constitutional importance and importance for public development of public law, and those which are specific to the, in some ways, special features of the sanctions regime and the special features of the facts concerning Mr. Shvidler himself. Looking at the first and probably the more important of those questions, I think it's worthwhile just to look at this against the background of the way that public law has developed in the last few years. This is one of a succession of cases in which the Supreme Court has retreated from the advanced positions adopted by an earlier generation of judges concerning the relations between the courts and the executive. As you pointed out a moment ago, and as Lord Leggatt pointed out in his judgment, this is essentially about the separation of powers. The first really significant milestone, I think, was the Shamima Begum case, followed by the Child Poverty Action Group case concerning the two-child benefit cap. In the CPAG case, the Supreme Court effectively said that when the decision on judicial review raises questions of policy, the courts should take their cue from Parliament and, so far as appropriate, from ministers answerable to Parliament. And that was in line with earlier decisions safeguarding the central role of Parliament in our Constitution, notably Miller I and Miller II. Shamima Begum, that was about the decision of the Home Secretary to stop her entering the UK in order to participate in her judicial review of the government decision to deprive her of her citizenship. Now, that was notable as a case where the evidence of Shamima Begum's threat to the United Kingdom was, so far as the judgment shows, extremely flimsy. But the Supreme Court deferred to the Home Secretary's greater institutional competence in matters of national security. The case of Mr. Shvidler really raises the same general area of principle as Shamima Begum, but in the context of the impact of the Human Rights Convention on sanctions against Russia and after the invasion of Ukraine. Now, as you pointed out, the majority held that although the court must itself decide whether there's been a violation of a constitutional right, it has to have regard to the superior institutional competence of a minister in matters of national security and in matters concerning the conduct of international relations. So there's a very wide margin of appreciation. Now, it was common ground that the sanctions pursued a legitimate aim, which they quite obviously did. The real question, as it seems to me, is whether the measures had any rational connection with that purpose. I mean, you don't get to the classic weighing of the individual's rights against the community's rights unless you can show that there's some rational connection. So really that issue essentially decides both issues 2 and issues 4 in the catalogue which you absolutely correctly set out a moment ago. Now, what the majority basically said is that there's no need to show that measures against Mr. Shvidler himself would in themselves make any difference, provided that they might make a difference as part of a wider assault on Putin's cronies. So that being so, they said that you need only show some plausible connection, some plausible contribution of the general gamut of sanctions of this kind. They then went on to hold that the regulations struck a fair balance between the rights of the individual and the rights of the community. Now, I think my own personal view, and I have in the past been a critic of the more interventionist judicial decisions on government policy and parliamentary policy. So I think that the general approach of the majority is in principle correct. My difficulty is in understanding how even on the majority's test, the sanctions against Mr. Shvidler could possibly be justified. There was a ferocious dissent by Lord Leggatt. The only difference of principle between Lord Leggatt and the majority really concerned the test for deciding whether a fair balance was struck. Lord Leggatt considered that the courts should not defer to the executive in deciding whether a fair balance was struck, but should make that decision itself. My own view on that question of law is that the majority had the better of that particular argument. So I don't have any quarrel with the way in which the majority decided the law. Where Lord Leggatt, I think, really scores is on the facts. In particular, the facts said to establish a rational connection between the objective of deterring aggression and the sanctions against Mr. Shvidler. Um, uh, they really were quite extraordinarily weak. Mr. Shvidler was sanctioned primarily on the ground that he was a crony of Roman Abramovich, who was in turn a crony of Mr. Putin. And it was said that the sanctions against Mr. Shvidler would serve to send a signal to other people in that sort of category about the cost to them of encouraging aggression. It was also said that the sanctions against Mr. Shvidler served to put pressure on him, to put pressure on Mr. Abramovich, to put pressure on Mr. Putin. So we're talking about a rather indirect chain of pressure. Now, Mr. Shvidler is a British subject. And as you've pointed out, this is especially onerous for a British subject because the sanctions bite on his assets wherever he is in the world. If he'd been a Russian, his designation would have been much less significant because it wouldn't have affected any assets that he might have elsewhere or anything that he might want to do with them elsewhere. Mr. Shvidler has lived in England for many years. There was no evidence that he'd ever voiced support for Putin. Indeed, the only known comment of his about the invasion of Russia, the Russian invasion of Ukraine, was a hostile one. There was absolutely no evidence that he had any influence on Russian affairs or in anybody involved in Russian affairs. Indeed, precious little influence on the precious little evidence that Mr. Abramovich himself had much influence. Mr. Shvidler was a non-executive director and a minuscule shareholder of a British mining company with interests in extraction in Russia before the invasion of Ukraine. But he resigned from that, as the facts set out in the judgment show, before he was actually designated for sanctions purposes. Now, Lord Leggatt was extremely critical of the suggestion that this amazingly remote connection with people who themselves had very little connection with the direction of affairs in Russia could possibly establish a rational connection sufficient to justify the really draconian effect. Because the licensing regime is extremely narrow, that these sanctions have had on Mr. Shvidler. And frankly, I agree with him. Indeed, I find it very hard to see. I mean, the majority didn't say what the executive says automatically goes. They did say that there was some function left for the courts to perform. But if the function of the courts is not engaged by facts as extreme as those of Mr. Shvidler, I find it very difficult to see how, in any other case, a delisting appeal is going to have any prospect of success. And since the general impression that one has about the sanctions regime is that sanctions designations have been flung about by the Foreign Office in a rather indiscriminate fashion, that seems to me to be a source of some concern.
So it sounds as if you had been on the court, you would have sided with the Lord Leggatt dissent on insofar as he says no rational connection.
Well, of course, if I had been on the court, I would have heard the whole of the argument of both sides. I would have read many more documents than I have actually read. I'm relying on the judgments themselves. So I can't automatically say yes to that question. But it seems to me, reading the judgments, that Lord Leggatt's assessment of the facts is very much more powerful than the majority's.
So can I just ask you a bit about that? So where does that leave the role of institutional competence and the constitutional role of the executive in making decisions based on foreign policy and so on? Are you saying that, as Lord Leggatt says, that goes so far, but onerous measures require proper reasoning, and where there is simply not adequate reasoning, one doesn't defer to the views of the executive, or you have to scrutinize them carefully, or?
Deferring to the views of the executive is not the same as simply accepting that the executive can conclusively make the decision for itself. What it means is that a considerable amount of credit must be given to the executive's superior sources of information and indeed judgment on an area where the courts are relatively less experienced, namely national security and international relations. But that's not the same as saying that the executive has a free pass. What it means is that the facts have got to be that much stronger in order to justify interfering with a decision. But it's hard to think how they could possibly have been stronger than they were in Mr. Shvidler's case.
And what do you think of Lord Legate's elaboration on the idea of institutional competence, that the question really comes down to what kinds of reasons are put forward? So what he says, as I recall, is that it's one thing if reasons are based on actual experience or particular sources of knowledge or expertise, on which I think he accepts as well that the FCDO would have institutional and actual expertise. But he draws a distinction between those kinds of reasons. And he then says, but the court is better placed if to look at the validity, consistency, basic rationality, and compatibility with common sense. So it is your view that it really depends what the FCDO had said in their witness evidence or in the reasons given at the time, what kind of reasoning dictates what form of, as it were, deference should be given by the court?
Well, it depends obviously on the totality of the evidence, including the evidence put forward by the designated person, and that's not only a question of looking at the Foreign Office's evidence. But I mean, I'm not sure that I would accept the distinction that Lord Legate draws between armchair theorizing, I think was his phrase, and looking at the crude facts, because the facts themselves mean nothing except in relation to the judgment that might properly be formed about them. And that judgment is something, it's a judgment that will be made by officials and ministers with considerable background experience of the way that governments react and that people who have influence over foreign governments react. So it seems to me that the absolute distinction that Lord Legate at times appears to have made between those two things is not really justified. It's a very porous distinction. So, I mean, I am on the whole with the majority there too. But again, if the reasons put forward by the government, and indeed taking account of the evidence put forward by the designated person, show that there's actually nothing in it at all, then one is entitled to conclude that the government has simply acted arbitrarily. In this case, there is also, I think, the problem of the selection of Mr. Shvidler. One of the points that Lord Legate makes is that all sorts of people have had a rather less tenuous connection with the extraction industry before the invasion of Ukraine than Mr. Shvidler. He cited BP as an example. And it is actually quite baffling why the government should have lighted upon Mr. Shvidler as a suitable person to designate, except possibly on the basis that they simply threw the book at absolutely everybody in sight who they could regard as having any kind of connection with Russia.
Well, I think another thing the courts have a look at, and certainly Lord Legate, is the original reasons which he deprecates as being baseless in a press release given by the government.
Well, they modified that.
They modified that, exactly. But in terms of the original reasons.
Yes.
Um, your point is very interesting about singling out Eugene Shvidler as compared with others, because that's right that Lord Leggatt talks about the non-sanctioning of BP and indeed of Sir Michael Peat in terms of other non-exec directors of Evraz. I was reminded of the Bank Mellat judgment, of course, on that point, and I wondered what you thought, because as I recall, one of the main issues that led you to say that the order made against the Iranian bank, Bank Mellat, was unlawful was that it was singled out as compared with other banks. Now, the
Well,
Lord
that's a classic indication of arbitrariness, isn't it?
well, Lord Sales and the majority had considered that, but didn't seem moved in this case by arguments about why him and not others. What did you think of that part of the analysis?
Well, I mean, the why him and not others point is not the most important point in the analysis, but it is entitled to some weight.
Right. And can I just ask you a bit more about this idea of institutional deference? Is it your view that the recent trend that you identify, certainly in the Supreme Court, has struck the balance about right? Or do you think that in recent cases there has been too much deference given to the government on grounds of national security and foreign policy?
I think that in general it struck the balance about right. I mean, of course, different cases have their own facts. I described the case of Shamima Begum as being pretty flimsy. But one of the problems about that case is that the Supreme Court was only looking at part of the issue, the particular questions that had arisen out of her desire to be in the UK for the purpose of conducting the broader litigation, challenging um, uh, uh, her deprivation of citizenship. And the fact that the courts did not, in that case, have a chance to view the whole position undoubtedly made that a rather more technical case. I wouldn't quarrel with the result, although I think that the legislation which was used to deprive Shamima Begum of her citizenship is seriously defective because it leaves people practically stateless simply because legally they at one stage did have a state. But that's, another issue. I wouldn't, I think, quarrel with the outcome of that case. In general, I think that the trend of recent cases, including this one, as statements of the relevant public law, is in the right place. I think that the courts are not in a good position, except in extreme cases, of which I think Shvidler's was one, to determine what the impact on national security or foreign policy will be of decisions like this.
And why foreign policy and international relations as opposed to all areas of government policy? So
Well,
take
there are others which
immigration
would,
or
I mean, there are others which I would put in the same category, such as intelligence work and defense. And there may be for other ones, but I mean, there are areas which are particularly sensitive, which call for an experienced judgment of quite difficult facts in which there may be considerations going in different directions. And so I think that the separation of powers does require a high degree of weight to be given to the way that experienced ministers and officials decide these matters.
but
I
wouldn't
don't have a problem with that.
wouldn't that go just as much for decisions on immigration or public health or anything else? They're all
No, not so much. Um, uh, because I think that we have uh, the public in general and the courts, as I suppose, in this respect, representative of the government, the public in general, have a much clearer grasp of the issues involved in for example, immigration cases, than they do of the much more arcane issues involved in defense, intelligence, foreign relations, and national security. And I mean, the emphasis on national security as a matter specifically within the competence of the executive is not new. It's a point which the courts have been making for very many years, and indeed, in some cases, they came close to giving the executive a complete carte blanche. I'm not in favour of that, but the wartime decisions on incarceration under Rule 18 were obvious examples of that.
And I think one thing that's interesting is the use of sanctions has expanded greatly. The Sanctions and Anti-Money Laundering Act authorizes sanctions in quite a broad range of areas. So I wonder if it's relevant that the concept of foreign policy is now quite expansive. So, for example, there are now sanctions on gross violations of human rights, anti-corruption, most recently illegal migration, query whether the UK will go the way of the US in having sanctions relating to organized crime. Does that mean, do you think, that the majority view and the trend of judgments in relation to deferring on these issues of foreign policy could result in really quite broad discretion being given on these other areas of too, because they loosely have the heading of foreign policy or international relations? Is that of concern?
I think that's what you say loosely have the heading. I think there's got to be a real foreign policy or defense or national security basis for the ministerial decision which is being challenged. I mean, one of the problems here, and I speak here very much more as a historian than as a lawyer, is that the whole idea of sanctions is a legislative idea. We have an elaborate legislative framework for imposing sanctions, so the courts have to approach the matter on the basis that sanctions are important and potentially productive. As a historian, I have to observe that I am unaware of any case in the whole of human history where sanctions have had the slightest impact on the policies of a foreign country. They are a complete non-event in terms of actual productive effect. But no court can, of course, take that view, because that is not the approach that the legislature has adopted, either in Britain or in other countries.
And do you think it's relevant to the degree to which the court should be scrutinising reasons in the way that you have described, what degree of parliamentary scrutiny there actually is? Because you talk about the role of Parliament, but of course, in the case of the Sanctions and Anti-Money Laundering Act, and it's not alone in this respect, it's a big delegation of powers to ministers. And so if the courts take the approach that it's not right constitutionally that they get too involved, is it problematic that that means you have neither Parliament nor the courts scrutinising what ministers are doing, or do you regard that as just
Well, I think the courts do scrutinise it, but on a basis which gives considerable weight to the judgment of the executive in certain areas. Moreover, Parliament is in a position to scrutinise whatever executive measures it likes. I mean, this was a matter which was touched on in my judgment, and I think in other judgments, in Bank Mellat, where it was suggested that because the orders against Bank Mellat had been through an implicit parliamentary approval process, that gave greater weight to the Treasury's decision. I think the problem about the argument in that particular case was that the Treasury had shifted its ground about the reasons for sanctioning Bank Mellat between the time when Parliament was invited to look at it and the time when the matter came before the courts. But in general, I would say that the existence of a measure of parliamentary scrutiny is relevant if there has been a real scrutiny or possibility of scrutiny, which Parliament has not taken up. That is a matter adding weight to the executive's decision. I wouldn't describe it as the most important of the factors, but that it is a factor, I have no doubt of.
And is the idea of institutional competence a pure constitutional matter, by which I mean, does it matter what the performance of a particular government department is like? So, I mean, there are various areas where the courts have got very involved in areas of governmental decision making that have not been so adequate. I'm thinking of the tainted blood scandal, Grenfell, whatever it may be. Does it matter what the actual competence of a particular department has been like? Or is it a matter of constitutional purity and the actual reality on the ground matters less?
Well, both of them matter. It's primarily a constitutional issue. It's about the separation of powers, as I think all 5 members of the court in the Shvidler case agreed. Um, so, but I mean, obviously, if the evidence about the basis on which the decision was made is completely unconvincing, then the courts have to react accordingly. I would be quite chary of taking a case in which, on its face, the decisions of the minister or the officials concerned did pass muster, but if you're suggesting that one should say, well, in a lot of other cases, they've shown that there are a lot of incompetence, therefore we should devalue the evidence that's given in this case, which would otherwise be decisive. Well, I don't think I would agree with that.
And of course, one feature of the reasons given in this case and discussed in both judgments is the timing of the reasons. And because the focus is on proportionality and the assessment of proportionality happens at the time the court decides it, that also gives the government the opportunity to put in witness statements, like the witness statements scrutinised in the case. So the scope for...
Well, they've got that opportunity anyway, and it may be relevant to other aspects of the 4-part test.
Yes, indeed, but because we're talking about proportionality, and actually, I was reflecting, proportionality is so important in this area because the definition of an involved person is so very broad, and I suspect both you and I are involved persons. Anyone who's had a Russian client at the bar, and anyone
Well, I
associated
very
with them.
famously did.
Well, exactly, and you know, did you know that probably your wife and children are involved persons for the purposes of Russia regulation? So it does put a bit of a focus on the role of proportionality in the analysis.
Yeah.
And actually, with that in mind,
And there's a big overlap, isn't there, between proportionality and rational connection? I mean,
yeah,
formally speaking, rational connection is a gate that you've got to go through before you get to proportionality. But actually, the evidential basis on which you look at both questions overlaps quite a lot.
yes, and proportionality sometimes is used to refer to the whole of your 4
Yes,
Bank questions. And
indeed.
actually, with that in mind, I suppose a potential at this point, I don't know about for this claimant, but it would be the European Court of Human Rights. So, I mean, could there be an ECHR remedy in a case where, you know, as you've said, if you disagree with the majority view that there is a rational connection, is that something? I know you're not a fan of the Strasbourg court in general, but is this one area where it could be a helpful remedy?
Well, I'm not, as you say, a fan of the Strasbourg court, but we've got the Strasbourg court. And the answer to your question, would there be any scope for them to review the matter, is quite clearly yes, there would. The Strasbourg court takes an independent view of its own, just as the British courts do, of the proportionality of the decision which is being challenged. And it has occasionally, even on matters involving national security, been prepared to take a view which differs from both the UK courts and the UK government. I mean, a rather striking example of that is the decision about the the three IRA operatives who were shot in Gibraltar some years ago. That was a very contentious decision. It was decided in Strasbourg over the heads of some quite powerful dissents, but it does show the extent to which Strasbourg will form an independent view. Indeed, a large part of my criticism of the Strasbourg court is precisely that they do form an independent view of matters which are, as it seems to me, wholly within the competence of the relevant constitutional organs of the United Kingdom.
But does that mean you would say in a case like this, even if, for your money, the reasons might not withstand scrutiny, if the Supreme Court of the UK says that they do, then that's the end of the story?
Well, I think that would be the right answer. But it's not the answer that the current law of England dictates. And therefore, in a conversation like this, I don't see any point in pursuing it.
Well, I'll move on in that case.
Well, I'm pursuing my own prejudices on this subject.
Only a couple more questions. I wanted to ask you, as a former member of the court, of course, about the role of dissents, because, this is a case where the dissenting judgment is getting as much attention, if not more, than the majority judgment. I mean, do you think it's right that there's been a recent tendency towards single judgments of the court and that that's been regarded as important? Is it significant that this is a dissenting judgment and it's a dissent of one?
Well, I think that there has been a stronger tendency to have single judgments. That's partly because experience suggests that concurring judgments are a nuisance because they, so far as they entirely agree with the main judgment, they add nothing. And so far as they add different reasons, they add confusion. So that is the reason for why there are fewer concurring judgments. There are also fewer dissenting judgments, but I think that is actually because the Supreme Court is a happier and more united place than it is, certainly on questions on public law, than it used to be. So that the amount of actual disagreement has diminished. That obviously is, I think, a source of reassurance because these are all very independent-minded people, and the fact that they agree is therefore entitled to some weight and indeed to some applause. The value of a dissent, it really depends entirely on the quality of the judgment of the dissenter. Lord Legate's judgment is a judgment of very high quality, which has attracted attention precisely for that reason. The advantage of a dissent is that although by definition a dissent is not the law, the fear of a reasoned dissent is a very important motivating factor in the majority to take a good deal of care about their reasons and indeed their conclusion. You are very much more careful as a senior appellate judge if you think that there are potential flaws in the logic which one of your colleagues may ruthlessly point out than you would otherwise be.
So is it your guess that there will have been attempts to persuade each other and come together on this issue? I mean,
I would certainly expect that to be the case. I have no knowledge of what happened in this case, but certainly when I was on the court, powerful dissents were an occasion for discuss. I mean, the judgments are all circulated in draft in advance, and people express their views upon them, and occasionally there may be further conferences between the judges involved so as to see how far their disagreements can be sorted out. And that's entirely healthy. And quite often, even if a dissenter doesn't manage to change his colleague's mind, he may have an influence on what the majority's reasons are and how those reasons are expressed. I don't know how much of that happened in this particular case, but I'm in favor of dissents. And the reality is that some dissents, and this I suppose is more true of the Court of Appeal than of the Supreme Court, have had a considerable impact. The dissents on some of the more contentious tort cases in the past generation had a very considerable impact and ultimately turned out to be the law. Um, uh, Lord Briggs was a famous dissenter in the Court of Appeal, and his dissents very often persuaded the Supreme Court, obviously as the last stop, sort of the Strasbourg Court. A dissent in the Supreme Court has less possibilities of making a difference, but it makes a good deal of difference internally, even if it doesn't externally.
Well, I noticed, and so have others, that Lord Leggatt draws attention to Lord Atkin's dissent in Liversidge and Anderson.
Yes.
And of course, there are some parallels.
Yes, there are. Except that in Liversidge and Anderson, the House of Lords basically declined to look into the Secretary of State's reasons at all. And, that's not what happened in this case. What happened in this case was that the Secretary of State's reasons were held to be entitled to very great weight, but nobody suggested that they were conclusive. And I think that's why Lord Leggatt's parallel with Liversidge and Anderson may not have been as close as he thought it was.
Were you surprised by the tone of his dissenting judgment? Because it's quite strong and somewhat reminiscent of US Supreme Court judgments.
It's perfectly judicial. I mean, the great master of modern Supreme Court of the United States dissents is Sonia Sotomayor. I mean, she's a good deal ruder about her colleagues than George Leggett was.
Indeed. Just a couple of things in addition that have been asked, and then we will draw this very interesting discussion to a close. But someone has pointed out, which is right, that under the Sanctions Act, there is a closed material procedure, which could be helpful in the sense that evidence can then be put before the court to assess the rational connection without too much regard to deference, because they're having regard
Well,
to closed.
it wouldn't make a difference to the degree of deference. It would simply make a difference to the evidence by which you assessed whether this was one of the exceptional cases where you should not defer.
Yes, I mean, interestingly, it's not so far been used, I think, in the context of sanctions.
Yes, there was some closed evidence in Bank Mellet.
Yes, indeed, indeed. Well, I think the other questions are quite specific, but was there anything else, Lord Sumption, that you thought was worthy of comment in the judgment? You've been incredibly...
I think I've been too expansive already.
I don't agree. But thank you to all of our listeners, and thank you so much, Lord Sumption, for giving so much of your time and analysis to this. I will draw this to a close with huge thanks.
It's a pleasure.